Welcome to the deep dive. This is where we take the material you send us and, well, really dig into it to pull out the knowledge that matters.
Mm.
Today, we're tackling something really crucial and pretty complex, the way mental illness and the criminal justice system intersect.
Yeah, it's a huge area.
One of you sent in a really thorough analysis. It looks across history, law, the development of things like mental health courts.
A cross-disciplinary approach, which is essential for this topic.
Exactly. So our mission for you, the learner, is to get a solid grasp of this relationship, the real challenges, the attempted solutions, and the critical analysis that comes out of these sources.
We want those aha moments for you, but without getting totally bogged down in detail.
Right. Okay, let's start unpacking this. Where do we begin?
Well, I think the analysis rightly starts with the absolute fundamental challenge,
Mm-hmm.
defining mental illness in a way the law can actually use.
Okay. Because it's not straightforward.
Not at all.
Yeah.
The source material emphasizes it's not just a clinical diagnosis you pick out of a manual. It's deeply tied up in social ideas. It's a social construct.
Meaning what society deems normal or acceptable shapes the definition.
Precisely. So the law isn't just taking, say, the ICD-10 or the DSM-IV-TR definitions wholesale.
Those are the big clinical diagnostic manuals, right?
Correct. Instead, you see legal definitions like the one in the Victorian Mental Health Act from 2014. It talks about a significant disturbance of thought, mood, perception, or memory.
Okay, that sounds quite specific.
It is, and importantly, it excludes certain things. Things like family conflict, or just the level of substance abuse someone has, or antisocial traits, even socioeconomic status.
Why exclude those? What's the thinking there?
Well, the implication is the law is trying to draw a line, perhaps to focus on conditions perceived as more directly impacting cognitive function or reality perception in a way relevant to criminal responsibility. But it means someone in immense distress might not fit the legal definition.
And therefore might miss out on specific legal pathways or considerations.
Exactly. And this analysis points out these definitions aren't even consistent across Australia.
Oh, really?
Yeah. Queensland, for example, ties its definition to internationally accepted medical standards. That seems like an attempt to bridge the legal and clinical gap.
Okay.
But then New South Wales requires a serious thought disorder. That sounds like a higher threshold, maybe.
It does. And the Commonwealth Criminal Code has its own version, too.
It does. Tasmania and the Northern Territory have comparable definitions, but the point is there's variation. It's not uniform.
So whether you're legally considered mentally ill could depend on which state you're in.
Potentially, yes. And the analysis, citing Fishstein and others, calls these definitions inherently political. They reflect choices about who gets access to certain legal responses.
That's a really critical point about inconsistency. Okay, so let's shift to the historical side. The analysis touches on how society has dealt with mental illness and crime over time.
Right, and it's a pretty grim history in parts, from societal segregation, often influenced by the church, separating people out, to early psychiatric ideas about sort of disordered brains being the cause.
In the treatments mentioned, formaldehyde, laxatives, cold baths,
Yeah.
it sounds quite brutal.
It does. And then later, things like lobotomy, and it's stark contrast to today. But the analysis makes a key point. Even historically, there seems to have been some recognition, however flawed, of a difference between mental illness and simple criminal behavior.
A sense that it was an illness needing a cure, separate from punishment.
Sort of, yes.
Yeah.
A distinction was often made even if the understanding and treatments were rudimentary or harmful.
Okay, and that historical backdrop leads into the deinstitutionalization movement, right? Particularly in Victoria, the focus of some of this analysis.
Yes, the big shift away from large psychiatric hospitals starting around the mid-20th century. The idea was to move people into community-based care.
The intention sounds good, more humane.
Absolutely. The analysis stresses the aims were noble. But the reality was different. The required changes in community support and, crucially, community attitudes didn't really happen sufficiently.
The analysis mentions habits of perception.
Yeah, Walker's term. These ingrained ways of seeing people with mental illness that are hard to shift. And John Stone's point about needing to tackle deep cultural prejudice, without that, just closing institutions isn't enough.
Because the consequences were pretty severe, weren't they? The analysis is quite blunt about this.
It is. We saw increased homelessness and tragically increased rates of incarceration among people with mental illness. Deinstitutionalization, without proper community support, had these major unintended consequences.
The idea of crimes of survival is mentioned, people offending out of desperation linked to their illness and lack of resources.
Exactly. And then there's the term transinstitutionalization.
Meaning people move from one institution, the asylum, to another prison.
Essentially, yes. The argument, like Peter Nell J. Taylor makes, is that correctional facilities became the de facto mental health providers, a role they were never designed for.
So, a well-meaning policy shift inadvertently created a pipeline from lack of community care into the criminal justice system.
That's a critical takeaway. It really sets the stage for why we need things like mental health courts, because the traditional system struggles to cope.
Right. Let's talk about those traditional legal mechanisms. The analysis reminds us of the basics: actus reus and mens rea.
The guilty act and the guilty mind. And it's the mens rea, the mental element, that gets really complicated with mental illness.
This is where the defense of mental impairment comes in.
Precisely. The analysis notes the burden of proof is on the defense to show the person wasn't sane at the time of the offense. The possible outcomes, guilty, or not guilty by reason of mental impairment, are hugely different.
And that last one, not guilty by reason of mental impairment, what does that typically lead to?
It can lead to things like supervision orders, specific treatment requirements, or sometimes even unconditional release, depending on the circumstances and assessed risk. It's handled under specific legislation, like Victoria's Crimes, Mental Impairment and Fitness to be Tried Act.
And incredibly, the Omnatan rules from 1843 are still relevant.
Still very much alive, yes. The analysis points out that key sections of that Victorian Act basically codify McNaughton.
Wow. What are the core principles of McNaughton again?
It boils down to whether, at the time of the act, due to a disease of the mind, the person didn't understand the nature and quality of what they were doing, or if they did, they didn't know it was wrong.
The analysis uses an old example from Stephen in 1883.
Yeah, the hypothetical person with psychosis beheading someone they think is a wax figure, or doing it knowing it's wrong, but compelled by an irresistible impulse. McNaughton helps distinguish those scenarios legally. Its endurance is quite something.
It seems almost counterintuitive, though. If you lack the guilty mind, shouldn't that just lead to a standard acquittal? Why a special verdict?
That's a point of debate. The special verdict allows for court-ordered supervision or treatment, reflecting a perceived need to manage potential ongoing risk associated with the underlying condition, rather than simply releasing someone. It shows the law grappling with balancing individual liberty, mental health needs, and public safety.
Okay. Then there's the issue of unfitness to be tried. That's different from the mental impairment defense, right?
Yes, completely different. Fitness relates to the person's state during the legal proceedings. Can they understand the charges? Can they instruct their lawyer? Can they follow the trial?
The analysis mentions the R.V. Pritchard criteria.
Yes, 7 key criteria, focusing on that capacity to participate meaningfully in the trial. If someone's found unfit, the trial usually gets postponed until they regain fitness, possibly with treatment orders in the interim. It's about ensuring procedural fairness.
Makes sense. So moving to sentencing. If someone is found guilty, how does a mental illness factor in?
Well, the standard sentencing goals apply: deterrence, rehabilitation, denunciation, community protection, as laid out in acts like Victoria's Sentencing Act. But crucially, the court must consider the offender's mental state.
Oh, so?
Things like their level of culpability. Was their judgment impaired? Does the illness reduce the need for a specific deterrence? Could prison worsen their condition? In Victoria, the Verdun's principles specifically guide judges on this.
Verdun's principles.
Yes, they set out how proven mental impairment can mitigate sentencing, affecting moral culpability, the impact of imprisonment, and the relevance of deterrence.
And courts can order assessments or treatment too?
They can. Court assessment orders, court-secured treatment orders. These are tools the court has, although the analysis notes limitations. Like a secure treatment order can't be longer than the prison term would have been. The offense still sets the outer boundary.
Okay. So all this complexity in the traditional system, it seems to pave the way for newer approaches, like therapeutic jurisprudence.
Exactly. The analysis introduces this as a major shift in thinking, coined by Wexler back in 1990. It's the idea that the law itself, the legal process, the interactions in court, they all have psychological effects on people.
Okay.
So therapeutic jurisprudence asks, can we make the law and legal processes function more therapeutically? Can they support psychological well-being rather than causing further harm?
So it's not just about the outcome, but the process itself.
Precisely. It looks at legal rules, procedures, the roles of judges, lawyers, everyone involved through this lens of psychological impact.
Are there criticisms?
Oh, yes. Concerns about paternalism, the court becoming too parental, or potential coercion pressuring people into treatment. But proponents like Winnick argue it's about offering therapeutic opportunities, not forcing them.
And this thinking helped fuel the rise of problem-solving courts.
Definitely. Mental health courts are a prime example, but also drug courts, family violence courts, indigenous courts like the Koori courts.
What's the common thread there?
They tend to be more proactive, less adversarial. They often involve a team approach, judges working with clinicians, social workers, case managers, to address the underlying issues, the criminogenic needs that are driving the offending.
The analysis notes a shift in language, too, from problem-solving to perhaps solution-focused.
Yeah, that's an interesting point. It reflects a sensitivity to language and avoiding potentially stigmatizing labels, focusing instead on finding solutions with the person.
Right. So let's zero in on mental health courts. Where did they start?
The first one is generally cited as Broward County, Florida, back in 1997. And they spread pretty rapidly after that, particularly in the U.S., but also Canada, the U.K.
What do they typically look like? Say, the Canadian model mentioned.
The Canadian model often focuses on pre-adjudication, dealing with things before a formal finding of guilt. There's a big emphasis on assessing fitness to stand trial, using collaborative teams, and having ongoing judicial monitoring of the person's progress with treatment and support.
And the UK. The Bradley Report.
Yeah, the Bradley Report in 2009 was influential. It really stressed addressing the underlying mental disorder, not just the crime. A key recommendation was having mental health nurses right there, on-site in the courts and police stations.
Integrated care, basically. How did this develop in Australia? Was it different?
A bit different initially. Australia already had mental health tribunals, but their focus was more on civil matters, involuntary detention, compulsory treatment orders under mental health acts, rather than directly interfacing with the criminal justice process for offenders.
But then specific court lists emerged.
Yes, things called mental health court lists started appearing in various magistrates' courts. And the analysis clearly states these are grounded in therapeutic jurisprudence principles. They're about diverting people from the traditional criminal stream towards treatment and support.
So Australia has both tribunals for civil mental health matters and these specialized court lists for offenders.
Broadly, yes, though the specific setups vary state by state. There were different mental health acts, ongoing reforms. It's a complex. Queensland actually has a specialist mental health court at the Supreme Court level, but its focus is quite specific, determining unsoundness of mind or fitness for trial, rather than being a diversionary program like the magistrates' court lists.
Okay, so Queensland's MHC is different. What about other states mentioned? South Australia, Tasmania?
South Australia has a magistrates' court diversion program. Tasmania has a magistrates' court mental health diversion list. They share features linking participants with treatment, judicial monitoring, often pre-plea or pre-sentence diversion. Western Australia has a mental health court liaison service.
So variations on a theme, all trying to apply therapeutic principles.
Pretty much. Different models, but a shared goal of intervening more effectively than the traditional system often can.
Which brings us to the main case study in this analysis. Victoria's Assessment and Referral Court List, the ARC list, started as a pilot in Melbourne in 2009.
That's right. And the analysis lays out its objectives very clearly.
What are the key goals?
The immediate goals are about getting participants linked with community services, addressing their basic welfare needs, improving mental health. Reducing reoffending is listed as more of a medium-term goal.
That's interesting. So stabilizing the person comes first?
That seems to be the philosophy.
Yeah.
Address the underlying health and social issues, and the reduction in offending should follow. It's a very therapeutic sequence.
How does it work in practice? The operational principles?
It's described as problem-oriented. Using judicial monitoring, the magistrate stays involved. There are specialist clinical advisors in court, proper assessments, case planning, strong links to community services, and crucially, the power to divert people away from standard sentencing.
Who's eligible?
Eligibility is quite specific. It requires a diagnosed mental illness, intellectual disability, acquired brain injury, autism spectrum disorder, or severe dementia. And this condition has to result in significantly reduced capacity in key areas like self-care, self-management, communication, or understanding the consequences of behavior. It's based on criteria in the Magistrates Court Act.
And how do people get onto the list?
Mostly referrals from lawyers, police prosecutors, or magistrates themselves. The analysis notes that self-referrals are actually quite rare.
Why might that be? Lack of awareness, difficulty navigating the system.
Probably a combination of those. It suggests a potential access barrier for people who might benefit but don't have someone advocating for them within the system already.
The data shows participation has grown over time.
Yes, generally increasing numbers of hearings and active participants, though referrals fluctuated. The main diagnoses are mental illness, ABI, and intellectual disability.
And it's a pre-sentence program.
Correct. Sentencing is deferred while the person participates. And successful completion can even lead to charges being discharged without a conviction or finding of guilt under Section 4Y2 of the Act.
That's a significant potential outcome. Okay, the big question then, does it work? Does it reduce reoffending? The analysis covers an evaluation study.
It does. Mirroring methodology used in similar studies, it looked at recidivism rates for ARC participants over 24 months.
And the findings.
Well, it's not a magic bullet. About 58% reoffended within 2 years. The average time was about 6.5 months. Most reoffending, 82%, happened in the first year.
Okay. Doesn't sound amazing at first glance.
But here's the critical part. There was a huge difference between those who completed the program and those who didn't.
How big a difference?
Program completers had a median time to reoffend of nearly 22 months. Non-completers, less than 5 months.
Wow, okay, that's substantial.
It really is.
Yeah.
And for those who did reoffend after being on the list, the severity of their new offenses tended to be lower than their pre-program offenses.
So completion is key. What predicted successful completion or staying out of trouble longer?
Successful completion itself was the strongest predictor. After that, being female and having lower pre-program offense severity were linked to better outcomes. Interestingly, age and the actual time spent on the list weren't strong predictors.
That's counterintuitive, maybe. You'd think longer involvement might help more.
Perhaps, but maybe it's more about the quality of engagement and achieving stability rather than just duration. The study emphasizes the importance of that judicial monitoring and follow-up care.
The analysis also mentions limitations like relying on official court data.
Right. It only captures offenses that lead to prosecution and conviction. It doesn't show the whole picture of behavior or near misses. Still, the findings are significant.
So the conclusion is that ARC is effective.
Yes, the analysis concludes it helps identify underlying issues, gives courts better options, connects people to therapy and services, and does demonstrably reduce recidivism, particularly for completers.
And there's ongoing evaluation involving community input.
Yes, the ARC evaluation group includes community and consumer representatives, which is vital for keeping it grounded and responsive.
What about recommendations coming out of this?
Key ones include extending resources to allow expansion across Victoria. It's still mainly metro-based. Also, giving more thought to victims, perhaps through specific education or resources, and ensuring that judicial monitoring remains central.
The analysis includes participant stories, too.
Yes, Appendix 1 has powerful examples, people reporting improvements in mental health, reduced substance use, finding stable housing, engaging with support networks. It really adds a human dimension to the stats.
And a reflection from a magistrate involved.
Yes, Magistrate Ann Goldsborough highlights the positive impact she sees on participants and their families, reinforcing the value beyond just recidivism numbers.
The analysis also checks ARC against standard criteria for mental health courts.
It does, the 10 essential elements. ARC ticks most boxes: planning, eligibility screening, judicial interaction, team approach, monitoring, etc.
But there's a challenge.
Sustainability. Funding hasn't really changed despite the program's growth and proven value. That's flagged as a major risk.
A common story for innovative programs, unfortunately. The research method was mixed methods.
Yes, combining the quantitative recidivism data with qualitative insights from participants and stakeholders for a fuller picture.
Okay, so wrapping this up, we've covered a lot: the tricky definitions, the historical missteps, the shift towards therapeutic approaches, the specifics of mental health courts, and a deep dive into the ARC list evaluation. You, the learner, should have a much clearer picture now.
Absolutely. And it leaves us with a key thought, perhaps for you to mull over. If programs like ARC show promise, what are the bigger systemic changes needed to really move away from simply criminalizing mental illness? How do we better balance therapeutic goals with individual rights and public safety within the justice system itself? There's still so much critical analysis needed, both in research and in practice.
A crucial question indeed. It touches on resource allocation, legal frameworks, societal attitudes, plenty more to explore based on what we've discussed today.